Clearly, the intention of the parties was that the entire operation would include and be completed by taking Mrs. Miller up the ramp and into the house. It is not sufficient for the plaintiff merely to show that the accident occurred during the time period covered by loading and unloading. The fact must also demonstrate that the injury resulted from some act or omission by defendants insured which was related to that process. The only explanation given for the mishap is that Mrs. Pitcher was unable to maintain her footing, and as a result, she lost control of the wheelchair. There was no testimony that the ramp was negligently constructed or that it was inherently defective. Mrs. Pitcher did not trip, nor was there any substance on the ramp which may have caused the wheelchair to slip. The most probable explanation for the accident is that Mrs. Pitcher either undertook that which she was physically incapable of doing or neglected to take precautions necessary to protect Mrs. Miller. Her actions may have constituted negligence, but that is not to be decided here. At this point, it is sufficient for the court to find that the accident was caused by some act or omission on the part of Mrs. Pitcher, which was accidental to the unloading process. There is testimony to the effect that the women stopped to chat for 20 minutes in front of the Pitcher home before attempting to take Mrs. Miller inside. The casual relationship between the accident and the movement of Mrs. Miller from the vehicle to the house was not broken by this brief delay. The parties knew the unloading operation would not be completed as planned until Mrs. Miller was safely inside the Pitcher house. There is nothing in any of the testimony to suggest that the ultimate destination of the trip was the Pitcher front lawn. To the contrary, both women expressed concern during this 20 minutes interlude over their ability to complete the operation. Deciding not to forego their original plan, Mrs. Pitcher attempted to take Mrs. Miller up the ramp. Furthermore, there is no evidence that this brief delay caused the accident or that it would not have occurred in its absence. The conclusion, therefore, is that the accident occurred during the unloading of an automobile and was causally and casually related to that process. The Aetna automobile insurance policy issued to Grace Miller excludes coverage for liability arising out of the loading and unloading of an automobile unless the claim is made against the named insured, a lessee or borrower of the automobile, or an employee of either of them or of the named insured. Since Mrs. Pitcher is not the named insured, a lessee, or an employee, the policy will cover her but not the other person. In liability only if she is a borrower of the vehicle. A borrower of an automobile has been described as one who uses the car for his own business or pleasure and not for any purpose in which the other is interested. In common everyday language, the term borrower, a generally understood to mean someone who has, with the permission of the owner, possession of and use of the property of another for his own purposes. The facts here indicate that the Miller car was used primarily for Mrs. Miller's benefit. The purpose of the entire outing was to provide the crippled Mrs. Miller with an opportunity to get out of the car. As a favor, Mrs. Pitcher drove to the Miller home to pick up Mrs. Miller. It was agreed that the Miller car should be used for the convenience of Mrs. Miller, and because it had wider doors, thus facilitating Mrs. Miller's entry and exit. Mrs. Pitcher had her own car, and the use of the Miller car worked no special advantage for her. In no sense of the word can it be said that Mrs. Mitchell was a borrower of the Miller car. Rather, She used the Miller car for the purpose of benefiting its owner, Mrs. Miller. Therefore, the Aetna policy provides neither primary nor secondary coverage for the pitcher's liability. Accordingly, the court finds that the absence of any other collectible insurance, Allstate, as excess insurer, became the primary insurer and has a duty to defend the negligence action against Mrs. Pitcher. The Broome County Cooperative policy affords coverage only after the limits of the Allstate policy have been exhausted. Furthermore, Broome County Cooperative is entitled to judgment against Allstate for the cost of the defense in the negligence action to date, including reasonable legal fees incurred in that defense.